Hi guys, welcome to my channel once again. This is Bar Talk with Ola and my name is Moghalu. Thank you so much for stopping by once again. If this is your first time, I implore you to subscribe to my channel. On this channel, I talk about law for the layman, for the lawyer, and for the law student. Whichever you are, you will find my channel very educating and very instructive. Please share the videos with your friends, leave comments on the videos, and like the videos. Thank you so much. Today I want to talk about a very important topic that's an offshoot of a phenomenon that we find ourselves participating in either actively or passively, every 4 or 5 years, or even more often than that, depending on who we are and what part we play in the politics of our societies wherever we find ourselves. I want to talk about election petitions, and like I said, election petitions are an offshoot of elections. So what is an election petition? Election petition is a special action or proceeding instituted to challenge the validity of election results or to challenge the due return of a candidate that has emerged or has been declared a winner in an election. Election petition comes after an election. I know there are a lot of things that we need to know and talk about regarding election petitions. So I will take them one after the other. But essentially, we need to understand that the governing laws for election petitions are the Constitution, which makes specific provisions that cannot be controverted no matter what, and the Electoral Act. I'm going to be talking about the Electoral Act of 2010 as amended. I know that the Nigerian Election Act is already due for an upgrade, for an amendment, or a total repeal, and a new law entirely, but it's still in the works. There are still there are movements pushing for the update, upgrade, repeal, and the enactment of a new electoral act in Nigeria. It's long overdue, it's necessary, and it's important to promote our democracy as a nation. But since it has not been done, I'm going to be using the Electoral Act 2010 as amended. There are a few other laws that govern election petitions in Nigeria, but essentially the Constitution and the Electoral Act are the most important governing laws for election petitions in Nigeria. And please, when I'm talking about election petitions here, I'm talking about elections up to the state level. So I'm going to be excluding the local government elections, because they are governed by different laws entirely. So please come along as we discuss election petitions. You know that in Nigeria, especially if you are a Nigerian, as at the time I'm making this video, by next year we're going to be having primary elections across different political parties, and by 2023 we are going to be having the general elections across the states and federal governments. So this is a very important topic. I hope you do come along as we discuss election petitions on this 38th episode of Bar Talk with Ola. Election petitions are brought to challenge the validity of election results or to challenge the due return of an electoral candidate that's been returned as the winner, or to claim that another candidate that has been declared the loser ought to be the winner. So I'll take it level by level. At the federal level, the Court of Appeal has the exclusive jurisdiction to determine election petitions regarding the president and the vice president. So the Court of Appeal is the originating court. You know that for normal civil criminal proceedings, you start from the trial courts. That's usually the high courts of the states, and then you proceed, and then you go to the Court of Appeal before the Supreme Court. But for election petition regarding the post of the president and the vice president, the originating court, the court where the election petition goes first, as at first instance, is the Court of Appeal. So the Court of Appeal is vested with the original jurisdiction to determine if 1. a person has been validly elected into the post of the president or the vice president. 2. if the office of the vice president or the president of the country has become vacant. And 3. if the term of office of the president or the vice president as ended or as terminated. This can be found in section 239 of the 1999 Constitution of Nigeria as amended. From the Court of Appeal, the matter goes to the Supreme Court if there's an appeal on the judgment of the Court of Appeal. Then we have the National Assembly Election Tribunal, which determines if a person has been duly elected or validly elected as a member of the National Assembly. And then we have the State House of Assembly Election Tribunals, who determine if a person has been validly elected as a member of the State House of Assembly in any state across Nigeria. By Section 251 and 272 of the 1999 Constitution as amended, the Federal High Court asked the jurisdiction to determine if the term of office of any member of the Senate or the House of Representatives or the State House of Assembly has ceased, if the term of office has ceased, or if the post has become vacant. Then they also have the jurisdiction. The Federal High Court asked the jurisdiction to determine if the term of office of a governor or a deputy governor has ceased or if the post has become vacant. Where there's an appeal on the decision of the Federal High Court regarding election petition for on the posts of a governor or deputy governor, the appeal goes to the Supreme Court straight away, not to the Court of Appeal. But where there's an appeal regarding the decision of the Federal High Court as to the posts of National or State House of Assembly membership, the appeal goes to the Court of Appeal, and that's the final court. It does not go further to the Supreme Court. That's the final court. I would also like to distinguish between, an election petition and an intra-party matter. Intra-party matters have been decided by the court to be pre-election matters. They are not to be misconstrued or misunderstood as election petition matters, but I will differentiate as I go further. I'm going to differentiate on that. But let's I want to talk about some of the very important features and guidelines for election petition, because like I said, election petitions are special proceedings. They do not go like other proceedings, other court proceedings, or other legal matters or actions instituted. They have strict rules and regulations guiding them, and flouting any of these rules and regulations could result in the petition being thrown out by the election tribunal, which will not look well or augur well for the petitioner. The first thing to note is that according to the Electoral Act, all actions arising from the conduct of an election are commenced by way of a petition, an election petition. So that's the first thing. An election petition tribunal, the second thing to note is that an election petition tribunal must be constituted 14 days before the election. 14 days before the election, and the registries must be open, to entertain, the activities and the complaints or inquiries of its frequenters at least 7 days before the election itself. There's a quorum for election petition tribunals. So each petition tribunal has a special quorum, which is already stipulated in the Electoral Act. I do not want to give out provisions of the Electoral Act because these provisions may change. We are open and looking towards, an amendment of the Electoral Act in Nigeria. But as I speak, we are still using the 2010 Electoral Act as amended. So by that act, and of course I know that by the subsequent act, a quorum has to be. So I wouldn't say that this is the number of the quorum per tribunal, because the number might change. But I know that this one will not change. That's why I'm talking about the things that will necessarily or definitely not change, even if we have an update or a repeal or an amendment or another enactment of the law. The third thing to note is that there must be a quorum, and that quorum must be complete. Where the quorum is not formed or is lost in the process of the election petition tribunal sittings, the proceedings become a nullity. It's just like, for instance, a normal court where 3 judges of the Court of Appeal are supposed to sit and only 2 or only 1 is sitting. It nullifies the proceeding. Or maybe the 7 justices of the Supreme Court and only 6 are sitting on the matter. Or maybe 7 started and then 6 proceeded along the line, 1 left or 1 was absent or was removed or anything happened, the proceedings will become a nullity. So that's the third thing to note about election petition tribunals. The quorum must be complete from start to finish of this tribunal sitting. Now, the fourth thing, and I think that's the most important thing, is that an election petition must be filed 21 days, 2 and 1 days after the results have been declared. That's very important. That's why I said earlier that it's a special proceeding. So this date cannot be changed, cannot be overlooked, cannot be waived for any candidate. So usually election petition matters are a situation of equity aiding the vigilant and not the indolent. You cannot sleep on your right because you act to sleep in perpetuity. So 21 days after the announcement of the results, if you're displeased with it, you file your election petition. And the registry has to have received it. We're not talking about you preparing it, your lawyer preparing it in his or her chambers. We're talking about the registry having received it within 21 days of the announcement of the election results. And I think it's important and very necessary, so that people don't come and file election petitions as an afterthought, or just to disrupt the polity. It's important for you to be to know what you're doing when it comes to election petitions. So they have to be filed 21 days, at least within 21 days after the election results have been declared. You have to file your election petition or forget about it. The fifth thing to note concerning election petitions is that an election petition tribunal must deliver its judgment within 180 days of filing the election petition. Don't forget that I said that you have to file your election petition within 21 days of the announcement of the result. Now, the date the result was announced is excluded. So you start counting from the day after the day the election results were announced. So after that, you have 21 days within which to file your election petition, and this day cannot be time limit cannot be waived for you no matter what. I'm going to read a quote that I love so much about this. It's from a decided case, and I love it so much. I'm going to have to read it to you later. Essentially, you have 21 days after the declaration of the result to file your petition, and the tribunal has 180 days after the filing of your petition to deliver its judgment. You would remember that or recall, or you would know or want to note from now, if you did not before, that for judgments, for normal court judgments in court cases, civil and criminal, the court has 90 days, after adoption of written address, that's after the conclusion of the case, for the judge to deliver the judgment in the matter. But for election petition, 180 days after the filing of the result. This means that the tribunal must sit immediately they receive the election petition, and all the evidence given and everything, the proceedings have to be concluded and the judgment delivered within 180 days. 180 days, that's 6 months, and I think it's very important and necessary, so that there won't be unnecessary breaks and lapses, in the politics, in the political calendar, so that there are no lacuna, and we don't have a situation whereby, there's nobody in the office at the moment. If you'd like to read up on the election petition time frame, you could look at the case of Moghalu and Ngige. You could look at the case of Kamba and Bawa, and if you'd like to look at the time frame within which the judgment can be given, the 180 days, you could look at the case of Abubakar and Goni. When there's an appeal on the decision of an election tribunal, I've talked about appeals from one court to the other earlier on. So where there's an appeal, it must be heard and disposed of within 60 days. So you would see that there are so many restrictions, time restrictions. And that's why you find out that sometimes you hear that, the courts are on strike, or you hear that, this land matter is going on for 10 years, this criminal matter has gone on for 6 years. But election petition matters, within 6 months, everything has been done, concluded. And if there's an appeal within 2 months, it's disposed of. That's because the law provides for time frames, and whatever is done outside of these time frames are nullities, null and void and of no effect. So that's very important to note. In Abubakar and Goni, the court held that the time frame for hearing election petitions remains 180 days. trial of an election petition is 180 days. Nothing can be added, nothing can be removed. And even where a court of appeal has, where there's been an appeal on the decision of the election tribunal, the originating the election tribunal of first instance, and probably they've ordered a trial de novo, it has to also be concluded within those 180 days. The time cannot be extended, and whatever an election petition tribunal does outside of those 180 days are null and void and of no effect. In fact, the court held that those days are prescribed by the Constitution, and so they are sacrosanct, they are unshakable and immovable, like the rock of Gibraltar or Mount Zion. They cannot be extended, they cannot be, moved. So whatever the court does or the tribunal does, after the effluxion of time, that's after the lapse of 180 days, is a nullity. So that's why you must have noted that, even when other court cases are dragging, election petition matters move on fast, and the judgment is delivered and the case is settled. Another thing I want you to note about election petitions is that sometimes you would look at the outcome and you would wonder if justice has been done. Most times, from what I've seen and read of election petitions, the trial is won, usually on the weakness of the party that's the petitioner, not necessarily on the strength of the respondent. So I told you that the petitioner could bring a petition claiming that the results are invalid, or claiming that the person that has been returned has not been duly returned, or claiming that instead of the person that has been returned, he or she ought to have been returned. So while they are claiming all these things, they do not have sufficient proof in support of their claim before the court. The claims will fail. So usually the respondents win on the failure of the case of the petitioner, not necessarily on the strength of the petitioner. That's what happens in some of these cases. Usually they have eyewitnesses. For instance, they might have eyewitnesses who witnessed ballot boxes being snatched, or things being done the wrong way. I'm using the Nigerian example now, for instance. But when it's time to come and give evidence in court, most of these people are usually threatened, or they are too afraid to come and give evidence, or they are compromised at the point of giving evidence. So their evidence becomes useless because they probably do not show up, and when they come, the court cannot really use what they have to say or what they have to give in evidence. So usually election petitions fail on the weakness of the case of the petitioner, not necessarily on the strength of the respondent's response. So like I always do, I'll tell you the parties in an action. So in an election petition, the parties are the petitioner and the respondent. I know you think that it sounds similar to the parties in the divorce petition because it's a petition too. That's why they are similar. I remember I did a video on divorce. If you haven't seen it, I'll put a link to the video in the description box. I hope you do watch it and share it, and leave me comments so that I get feedback from you. But in an election petition, the parties are the petitioner and the respondent. So who can be a petitioner in an election petition? Because it's not open to the whole world. In fact, there have been cases decided in court whereby the person that instituted the petition was held by the court to have no local standing before the court to even bring a petition. So who can bring a petition in an election petition? One, a candidate in an election can bring a petition. That is a candidate that was put forward by a party who actually participated in the election as a candidate can bring an election petition. Two, the political party that sponsored a candidate in an election can bring a petition. Three, a person who is validly nominated and cleared but excluded wrongfully by INEC can also bring a petition in an election petition. Note that I said excluded wrongfully by INEC, not by his political party. If he was excluded by his political party, that's a pre-election matter. I said I was going to differentiate much later, so let me just do it now. Pre-election matters are usually intra-party matters, so sometimes people confuse it. So when you're having primaries, for instance, you know that a lot goes on during primaries, a lot goes on, a lot of intra-party politics goes on. So for instance, if a candidate that came forward as a candidate in the primaries was excluded by his own party and so could not participate, talk less of becoming, the candidate that is fielded by the party in the general elections by INEC. That person or that candidate cannot come and sue or bring a petition, an election petition. What he can do is, sue as a pre-election matter. It's a different matter from an election petition. Because if you did not make it to the INEC stage and you were not excluded by INEC, if you were excluded by your own party, you cannot come and bring an election petition. You can only bring a pre-election action or suit to court. But if you were validly nominated by your party and cleared by INEC, but then you were wrongfully excluded by the same INEC, either maybe they forgot to put your name on the ballot paper, or they excluded you in one way or the other, you can bring an election petition alone or alongside your political party who fielded you in the first instance. So for the difference between pre-election matters and election petition matters, you could look at Amaechi and INEC, that's a decided case. You could also look at Odede and INEC, that's another decided case, Nigerian cases. The court and indeed INEC would usually not meddle too much in intra-party matters. So the ideal thing would be that parties sort themselves out. If they have any intra-party disputes, go to the high courts or go to the right courts, to settle the disputes. But as soon as you have cleared, nominated, and put forward a candidate for INEC to adopt as a candidate during the election, the general elections, then you can now join issues with INEC and bring an election petition where, you're dissatisfied with the conduct of the election or the outcome of the election. Who can be a respondent? I've talked about the petitioner. Who can be a respondent in an election petition? One, the person that won the election. That's the candidate whose election is being complained of by the petitioner can be a respondent. The party that fielded the candidate that won, the candidate whose election is being complained of, the party that fielded him or her can be a respondent. And of course, INEC can be a respondent. So they can be sued jointly or they can be sued individually. That is, a petitioner can decide to sue only the winner, or the winner and the party, or the winner and the party and INEC. By the way, INEC is Independent National Electoral Commission. That's the national body governing elections in Nigeria. There are states, electoral bodies, but the general one is INEC. That's why you would hear me mentioning INEC. When a petitioner complains of or is dissatisfied with the conduct of an INEC officer, it's enough that he sues INEC. That is, INEC is vicariously liable for the conduct of its officers. So when suing, you don't have to sue, Mr. Dalatu Yahaya was the polling unit officer that conducted the election that I'm complaining of, or was the returning officer, or what have you. You cannot sue Mr. Dalatu Yahaya. You can only sue INEC. INEC will bear the brunt for all its officers. So it suffices to sue INEC as the disclosed principal of its electoral officers, who are merely its agents. In the case of an election petition, for election petitions and unlike class actions, losers cannot jointly bring an action. That is, if A, B, and C have lost to D, A, B, and C cannot join forces and then bring an election petition against D. A has to bring his own petition, B has to bring her own petition, C has to bring their own petition, and then the court or the tribunal can now consolidate both all petitions, before it, but they cannot consolidate it themselves before bringing it before the tribunal. The tribunal can decide to consolidate it for ease and fastness in hearing the case, but they cannot on their own consolidate and bring a class action against D. Here are the stages of election. I'm telling you the stages because I want to make a point. There's the nomination stage. That's where candidates are nominated. There's the accreditation stage where nominated candidates are accredited. Those who are successful move on to the voting stage. After the voting, there's the collation stage. The results are collated, and then there's a declaration of results stage. And after that, aggrieved parties can now bring election petitions against winners in the election, or their parties or INEC. Now, someone that has not participated in all stages of election, of these elections, like I've outlined, cannot bring an election petition and cannot also be declared a winner in an election. Someone that has not participated in all these stages cannot be declared a winner. So they can neither be a petitioner or a respondent in an election. Petitioners must ensure that they bring the petition to the appropriate election petition tribunal. That's why, I made it a duty to outline the election petition tribunals that are applicable to each election and each candidate at the beginning of this video. So if you bring your election petition to the wrong tribunal, it will be struck out. And if it is struck out and you do not reinstitute it before the appropriate tribunal within 21 days, you lose the right to bring an election petition. That's the decision in Moghalu and Ngige. You'd like to read that case. Another thing to note is that when bringing an election petition, petitioners have to pay security for costs. Security for costs is just money that you deposit, with the election tribunal at the registry. It's mandatory, and I think that this has been made a rule so that people would not bring all manner of frivolous petitions before the tribunal. So it's not a free-for-all affair. You have to be sure that you have a credible case before you come before an election tribunal, and you have to pay the security for costs. You have to pay it. If you do not pay it, the proceedings are stayed until they have extracted the security for costs from you. So election petition is no child's play. Now, in bringing an election petition, you have to include the grounds for the petition, and then you have to include the facts in support of the grounds. You would note that this also sounds very similar to divorce petitions. Please watch the video if you haven't watched it. I'll leave a link to it in the description box. Like I said, you have to include grounds for the petition, facts in support of the grounds for the petition, and the prayers of the relief sought before the tribunal. The prayers of the relief sought before the tribunal are basically just two. That's that one, you want the court to declare you as the winner in the election, having polled the highest number of valid votes during that election, or you want the court to declare the election a nullity and make an order for a consequential, and to make a consequential order for a by-election. Now, you cannot ask for the two together. You can't say that they should declare you a winner and then declare the election a nullity. So you have to either ask the tribunal to declare you the winner, or to declare the election a nullity and make a consequential order for a by-election to be conducted. Now, note that if you're asking for either of these prayers or reliefs, the grounds you have stated and the facts in support of the grounds must be compatible. They must match it. So if you have put forward grounds proving that you're the winner, you cannot ask for a nullity, an order of by-election, because if you ask for that, you're basically nullifying your own election. So either you ask and you advance grounds and facts in support of the ground that you are the winner, or that the election was invalidly conducted and is a nullity and a consequential order of a by-election be made. Generally, election petition matters are civil matters. So usually the evidence is weighed on a balance of probability. That's what we call preponderance of evidence. But where there's an allegation of crime, it has to be proven beyond reasonable doubt. So these are the things that I'd like you to note about election petition. Essentially, I've been able to establish the facts that election petitions are serious matters. It's not just something, a product of wishful thinking, not something that you just wake up and feel that, oh, I don't want the election to go the way it went, or I can't just allow peace to reign, I can't just allow things to just move on, let me file a petition. It doesn't work that way. There are so many rules and regulations, hurdles to cross, and it has to be a product of, vigilance and due diligence. The time frame within which you have to bring your petition, you have to bring it within that time frame. The tribunal has to sit within 180 days, conclude and deliver its judgment and all of that. If there's an appeal, the appeal has to be delivered. The appeal has to be concluded and done with within 60 days. And of course, there are days, specified days, if you would check the Electoral Act and the Constitution, within which a petitioner should file his petition, and the respondent would respond, and the petitioner would give a reply to the response of the respondent, and so many other things. There are time slots for evidence given by the petitioner's witnesses and the respondent's witnesses, and so many other things go on. And of course, there are specific qualifications for who can bring a petition and who can be a respondent. So it's no child's play. I'd like you to watch this video over and again for you to properly understand what goes on in and with an election petition. And I hope that you've learned a new thing or two from this video. That's all I have for you today. I will always see you in my very next video. Toodles!